Yes, good morning.
May it please the Court, I appear for Mr Rowntree with Mr Williams. My learned friends Miss Demetriou Casey and Miss Thomas appear for the PRS.
Yes.
The Court will have seen Mr Rowntree appeals against the Tribunal's decision to strike out his claim and refuse certification. The appeal raises two issues of wider significance. The first arises where a class-wide loss has been at least arguably established. Does the proposed class representative have to show at certification exactly which people within the class bore that loss? Or can this be established later through top-down methodology? We, of course, say that it can. And secondly, what can constitute an arguable abuse of dominance by a compulsory trading partner in respect of its membership terms? As the Court has seen, this claim seeks to remedy what we say is a structural bias in the way the PRS distributes music royalties. It's brought on behalf of 160,000 songwriters, both to remedy the harm of the past, but also to establish a lawful methodology going forwards. And according to the PRS, this bias, even if made good, is not even arguably unlawful. It says it doesn't matter at all. Well, we respectfully differ, and I'll explain why, and why we contend the tribunal erred in law. Now, as the Court has seen, the immediate object of this appeal is to obtain a remittal. As the judgment explains, new legal advisers were instructed when the certification hearing was part heard. That's paragraph 11 of the judgment. There had been a CPO, a certification hearing, that itself had gone part heard. The issue of proportionality had been deferred. And at that stage, the new legal team was instructed. An application for adjournment was made in order to revise the certification materials, and it was refused. Although the tribunal indicated it was receptive to the submission, that had it not struck out, there may have been the opportunity to do so. So, of course, I'm not here today to advance a new case. Ladder Marshall, obviously, stands in the way, but we're not as pessimistic as the PRS about the ability to do so, and I am going to make some high-level points about that in due course. But first, what I propose to do, if I may, is talk a little bit about the facts and then go to what we say are the tribunal's errors of law.
Yes. And just for the avoidance of doubt, we are having a transcript, and the Court will be supplied with a copy of the transcript. It just affects the detail of the notes we take.
Thank you, my Lord, that's helpful. Well, I'll try to make sure I give bundle references for that purpose, even where I'm not going to documents.
Thank you.
As the Court's seen, this case is about the distribution of royalties for the public performance of musical works, such as songs. And that public performance could take place on the radio, on television, in pubs, or through online music services like Spotify. And the PRS, the respondent, is the collective management organisation for the UK for those royalties. And in simple terms, it distributes royalties to two types of persons. One is songwriters, like Mr Rowntree, the creator of the music, and songwriters like Mr Rowntree, assign their performing rights to the PRS for this purpose. That's the first category. The second category is music publishers, like, say, Universal Music, and they handle matters such as music licensing. Now, a song may have many different writers, like, for example, the members of a group, like Mr Rowntree's group, Blur. And each writer may even have its own publisher. But whoever they are, and whatever their scale, to all practical purposes, they have no alternative but to rely on the PRS for the collection of these royalties. So as the UK's only collecting society, it is a de facto compulsory trading partner. And just for the transcript, you can see that the PRS has taken no issue for certification about whether it's dominant as a result. And that again for the transcript, supplementary bundle, tab 2, page 52, paragraph 33 of the PRS's response to the CPO. So for certification, the issue is whether the rules are an abuse of that dominant position. And as you've seen, this is a case about what we call the black box royalties, the undistributed royalties. But I want to say something first about the PRS's methodology for matched royalties, the ones it does allocate and which are not in dispute in this claim. And it's fair to say that the PRS method of distribution for matched royalties is complex. And if I might ask you to turn up Mr. Arbor's witness statement at supplementary bundle tab 3, oh dear, mine has burst, it's page 81, paragraph 12. Let me just reassemble my own bundle. Yes. Page 81, paragraph 12. And it talks about standard distribution method, and it identifies three: 12.1 census, 12.2 sample, and 12.3 analogy. And I'm just going to unpack slightly what this really means. So in respect of census, Mr. Arbor gives the example of BBC Radio. And here, the PRS gets a record of exactly what was played, in theory, and pays out to those artists and publishers, in theory. But where it can't use or doesn't use a census, it uses sample or analogy. And the example for sample that's given is BT Sport. And he says, this could be appropriate where music usage is repetitive or a small breadth of total repertoire. And then there is analogy, where a sample taken from one source is used for others. And he gives the example of pubs, where the PRS visits certain pubs on certain days and applies its findings by analogy. Now, you don't have it in the bundle, but Mr. Arbor exhibited the PRS's distribution methodology, and it explains there are over 60 categories of this kind. And it distinguishes in quite a lot of detail. For example, South Asian restaurants is one category, East Asian restaurants is another. It distinguishes aerobics classes and shops at Christmas. And all of these use different methods, and indeed I think in some cases a cocktail of these methods. So it's a complex methodology, but it's not actually, in all respects, precise. And I'm still talking about when the royalties are paid out, not the black box. So if we take the example of pubs, a sample is carried out at some pubs and applied by analogy to others. I think the minimum time for a sample is over 4 days. So suppose the sample is taken at a pub that plays a lot of music by Taylor Swift, say. She will receive royalties for plays at another pub, even if that pub specialises in death metal. And the death metalists will be left empty-handed.
May I just ask what the relevance is?
Well, what it goes to...
there isn't a complaint about the matched royalties.
I've almost finished the point, my lord.
Sorry.
No, it's quite all right. But what it shows, the first thing it shows, which is, I hope, self-evident, is that even the distribution of matched royalties is approximate and involves some degree of extrapolation. And I'm going to contrast it to both the way in which black box royalties are allocated and then what that tells us about how the PRS could easily do better. That is the direction of travel. But that point is now finished. So let's now turn to the black box, which, as my lord says, is entirely the sole focus of this litigation. And these are performances where the royalties have not been matched. So the PRS, through its methodology, is left with unallocated royalties. And again, for the transcript only, this is summarised in the judgment at Core Bundle 7, page 92, paragraphs 22 to 24. But there are, in very simple terms, there are two main situations. One is just a form of data error in the PRS database, where some of the details of the parties who are due to receive the royalties are wrong. So they know which song was played, but a data error means the money doesn't get to the right place. And it's important to say that this is a problem that can affect very successful artists. It's not only a problem for the small and obscure. And Mr. Rowntree gave some evidence about this, which again, I'd like to show you very briefly, please. It's in the supplementary bundle. It's under tab 6 at page 147. And he talks about, if we could look at paragraph 15, he explains in the witness statement that he also suffers from these data problems. And you can see, he says, the suggestion at 13, any artist like me or any artist will have perfect data and be paid accurately is, in his words, absurd. This is because even assuming perfect data, there are problems of usage reporting. And he gives examples below. And you'll see one of his most successful songs is called Song 2. And then, I won't take your time with it, but he then explains there are ways in which there may be errors about recording the name of the song or the artist or the precise people who are listed as songwriters, if the writers are listed as Blur, rather than the 4 individuals who make up the band. And indeed, if the song is recorded wrongly as, let's say, Song 3, he may not get royalties. Now, in principle, given infinite time, money, and patience, this kind of error could be corrected. Mr. Rowntree is demonstrating it just here. He knows who the songwriters were for Song 2, and he knows that its true name is 2, not 3. But that would obviously require enormous amounts of time and resource on an ongoing basis. And as I've already said, there are 160,000 songwriters. Some, like Mr. Rowntree, have hundreds of songs. And I want to be clear, it is not our case that the abuse of dominant position exists in either not having a perfect database or not making correction for every single data error. As I'm going to come on to, we accept the PRS can only deal with this issue through some kind of top-down methodology, whether sampling, extrapolation, or a combination. But that was category 1, which I've called data error. But the other category is where the music simply cannot be identified. So suppose, for example, it's just recorded as bar music. Of course, we accept the PRS could never work out whose music was played in the bar on that particular day. Of course not. So no system of allocation can ever be precise. But what we do say is that just like the matched royalties category, some form of approximation is needed. But what I want to do now is talk about what the PRS actually does.
So I can just ask about that one. So that's where it's played somewhere where the third measure of matching doesn't apply. So the analogy doesn't apply.
So let me be more precise, my lord.
Yeah.
So if you imagine that the PRS gets information back from, Mr. Dimitri will tell me I've got this wrong, but say a television program that's being made, and they've got background music, and all the information the PRS gets back is bar music was played. Music was played in a bar.
Oh, so it's not actually music playing in a bar then?
Yes, maybe my example's not very good, but they may know exactly it's Blur Song 2 or Taylor Swift, one of her big hits. Then there may be just it's unknowable to the PRS that some kind of music was performed in the background in the bar, say, and all the PRS knows is some music was performed in this in the television program, say. So we accept that there are those difficulties.
Just while I'm here, can I ask about Song 3?
Yes.
If Song 3 is recorded, is the publisher accurately identifiable?
Well, it may or may not be. Right. I mean, but in any event,
you said it affects all songwriters.
It's a non-existent song.
It may affect publishers as well.
Yeah, absolutely could. Absolutely could.
My understanding is that a pub, say, pays a single license fee
that's
to play anything in the repertoire.
That's right. Sorry, there are some areas, some people pay a blanket license fee, like, for example, I think the BBC. Again, Mr. Dimitri will know, but you're right, there are blanket license fees And then there are repertoire licensing, so you pay a specific fee per play, but the PRS's methodology is then to allocate that revenue by reference to what was actually played.
So are the licensees, the pubs and so on, under any obligation to tell you which songs they've played?
No, it's done through the PRS. I think the answer is the repertoire licensors, such as the BBC, do. Exactly what their contractual obligations are, I'm afraid I don't know. But the PRS itself carries out surveys in order to build its sampling method.
Okay, thank you.
Again, I'll be happily corrected on some of this detail if I have it wrong. But what I want to do now is turn to the unmatched royalties, which this claim is about, the so-called black box royalties, as we call them. And here, there is essentially just a simple proposition. The PRS allocates the unmatched royalties pro rata to the royalties that can be matched. And this is noted in the judgment at paragraph 56, Core Bundle 6, 103. And the PRS's skeleton confirms this. And that's in Core Bundle under tab, I think 4. Tab 4 or 5? Tab 5, I'm sorry. Page 59, paragraph 12. That is what happens, even though within that there are lots of different categories. And what that means is if Universal Music gets 5%, say, of distributed royalties, it gets 5% of the black box. And I want to make two immediate points about this, about the evidence. The first is the PRS is silent about how or why this particular policy was adopted, why they chose to do it on this way, on this basis. It doesn't say that it accurately reflects the true entitlement of songwriters to these royalties, or publishers even. It doesn't say it even has considered that question. It doesn't say it thought about alternatives and discarded them as too difficult or too expensive. The highest its evidence goes is a general discussion of its objects and indeed its process. And of course, if the claim is certified, it will have the opportunity to address that. We accept that. But this takes us to the issue that the case is really about, which is Mr. Rowntree's case that there is a structural bias towards one of the two groups of PRS members. And that means that this leads to under-recovery by songwriters as a group. And he served some industry evidence about this. And in a nutshell, the errors were more likely to be songwriter errors than publisher errors. But for today's purpose, of course, you do not need to adjudicate that question in any way, because the tribunal proceeded on the basis that this factual assertion was arguably true. And it may be helpful to see that in the judgment. That's in Core Bundle 7 at page 104. In fact, I'd like to, forgive me, start at page 93. There are two paragraphs I'd like to show you. Page 93, paragraph 29. There is no complaint about the efforts to which the PRS go to identify works and or writers. The PRS has not disputed that royalties associated with unidentified works are in certain cases distributed pro rata. In fact, its acceptance in the skeleton is broader than that. Nor at this stage of the proceedings does it contradict the contention legal persons who should be entitled to royalties but cannot be identified are more likely to be songwriters than publishers. And then if we go, please, to page 104, we see at paragraph 57, we accept it is arguable that the proportion of writers' royalties that are black box is greater than the corresponding proportion for publishers. We accept it is arguable that when black box royalties are distributed pro rata, rata members will receive a lesser sum than they would were they to be distributed in accordance with a formula reflecting the proportion of writers' works which give rise to black box royalties. And the PRS indeed has never denied this. In fact, its position remains, even in front of this court, that it's just not admitted. This is in its skeleton argument at paragraph 28, Core Bundle 5, page 65. And the allegation was first made in pre-action correspondence some years ago. The PRS has served 5 witness statements, but it simply remains in its position that this is just not admitted.
Just to understand how that works, I know it's accepted, but just how it works in practice. You gave 2 examples of how the errors can arise. The first is data errors, where you accept it could impact publishers and songwriters. The second is the music can't be identified. The second one surely affects publishers and songwriters equally.
Well, in principle it does, yes.
So it's the first one we're concerned with, really.
Well, it's hard for me to go that far, but it's most obviously a problem with the first one. It then raises a question about how one would fairly deal with the other category.
But the monies we're talking about arise from both.
They do.
There's not a separate claim in respect of each of those subcategories.
It isn't. They are both in the claim, and the high-level proposition applies essentially across that claim. So, as I said, the PRS hasn't sought to contest this claim on the basis there is no difference in treatment between the 2 groups. Instead, its case is really that it just doesn't matter. And I'm going to come to that in due course. And with that excursion into the facts, I want to turn now to what we say is the first error of law. And this is about the question of what the proposed class representative...
Can I just ask about the proposition you've just put forward about the difference between the 2 groups? It may be you want to come on to this. But there's nothing under the rules in a matched distribution which would lead to distribution in accordance with which group you're in.
No, but the match distribution works by essentially allocating to the publisher's share, and the songwriter's share.
But to individuals.
To individuals.
It doesn't say we've got all of these match royalties in, we're going to give half to the writers and half to the publishers.
No.
So there isn't, as it were, a group-by-group distribution rule.
That's right. It's done on a performance-by-performance basis.
And an individual-by-individual.
Exactly so.
Basis.
But what we say is that in respect of unmatched, it in effect sets up this unequal treatment between what are in effect the 2 client groups of the PRS. That's the case. So I want to now turn to what we say is the first error of law, and I'm going to develop some law, and then I'm going to go to the tribunal's reasoning. But the essential issue is this. The tribunal accepted, as I've just shown you, it's at least arguable that songwriters as a whole receive less black box royalties than they would if they were allocated in a way that reflected their true share. That's what I've just shown you. And I have to accept at this stage, we cannot identify which particular individuals within the class has actually suffered a particular level of loss. There is, of course, information asymmetry between the PRS and the PCR, because we, of course, don't have access to the data. But also, to foreshadow what I'm going to say, a methodology for establishing liability in this case will have to be top-down. In other words, based on an overall approach rather than a bottom-up approach where we look at individual cases. And like the PRS's own methodology for matched royalties, it is bound to involve some approximation. And I want to explain why we say that is sufficient by going to the law. I'll start, please, with the Competition Act itself, which is under tab 1 of the First Authorities bundle, at page 4. And these are just the governing sections that deal with competition damages claims and class action claims in particular. Section 47A is the provision that allows damages claims to be brought before the Competition Tribunal. 47A1, a person may make a claim to which this section applies in proceedings before the tribunal. 2, this section applies to a claim of the kind specified in subsection 3, which a person who has suffered loss or damage may make for a breach of the competition rules. And then 3, on the next page, the claims are A, a claim for damages, B, another sum of money, or C, a claim for an injunction. And here, both damages and an injunction are claimed on behalf of the class. And then if we move on, 47B on page 6 is what enables these claims to be combined. Subject to the provisions of this Act, proceedings may be brought combining 2 or more claims to which section 47 applies. And then the various requirements of class action certification are set out in 5 and onwards, and I'll just highlight a few. 5, the tribunal may make a collective proceedings order only if it considers the person who brought the proceedings is a person who, if the order were made, the tribunal could authorise. Then B, in respect of claims which are eligible. 6 explains eligibility. Eligible for inclusion only if the tribunal considers they raise same, similar or related issues of fact and are suitable. And the requirements of suitability are set out in the tribunal's rules. But then, very importantly for this purpose, is on the bottom of page 7, the next page, 47C2. And this is the provision that has been the focus of a lot of litigation. Collective proceedings, damages and costs. The tribunal may not award exemplary damages, we're not concerned with that, so sorry. Over the page 2, this is the important provision. The tribunal may make an award of damages in collective proceedings without undertaking an assessment of the amount of damages recoverable in respect of the claim of each represented person. And famously, and as we'll see in a minute, this has been held to mean that liability can be established on a top-down basis. But before we go to that case law, I want to show you one other aspect of the requirement for certification, which we find in the Tribunal's Guide to Proceedings. And I'm afraid that is in the other authorities bundle. And it's at the, right towards the back under tab 23. We're going to need the first authorities bundle again in a moment, so I'm sorry to go back and forth. This is the Tribunal's Guide to Proceedings, and it's we want to look, please, at the bottom of page 1099, paragraph 637.
What is the status of this document?
It is tribunal guidance.
So it's not. They're not rules. They're not.
No. Does it have the status? It might have the status.
It's got the status of a practice.
I think it's a practice. Thank you, Lord. You're right. That is what it is. It's a practice direction. So 6.37. To make a CPO, a collective proceedings order, the tribunal must be satisfied the claims are eligible, and then it talks about the requirements for eligibility. And one is it must be brought on behalf of an identifiable class of persons. And it's not disputed that we satisfy this requirement. It's what it says on the next page that is helpful to see. In the second paragraph, accordingly, class definitions based on subjective or merits-based criteria, for example, persons having suffered loss as a result of the defendant's conduct, should be avoided. So you can't say, for example, it's all persons who have suffered an overcharge in the case of a cartel or something like that. The person needs to be able to identify whether they fall within the class at the outset to decide whether to opt in or opt out, as the case may be. But it can't be on the basis of essentially whether they have in itself a valid claim. And I now want to show you two leading cases on the meaning of this regime. The first is Merrick's in the Supreme Court, probably the most famous case of all in this jurisdiction. I apprehend you will have seen it before. It's in Authorities Bundle 1 under tab 6. I will, if I may, just take a moment on the facts as well as the critical parts of the judgment.
Just before you do that, I understand the point you make about you can't define the class by whether you win the action, because then you wouldn't know if you were a claimant until after judgment, and that's
it.
That's impossible. But in principle, when one looks at 47A and 47B, 47A says an individual can bring a claim for damages or an injunction if there's been a contravention of Chapter 1 or Chapter 2. And then 47B says you can join more than one claim together. So although you can't define the class as people who have claims, it must be the intention that if you bring a collective proceedings, it's actually an agglomeration of all the class members' individual claims.
Yes.
So your claimant's proposition is that each individual in the class does have this claim.
Yes, that absolutely. And where I'm going to now is what the consequence of that is in terms of methodology.
Yes.
So,
okay, thank you.
My Lord, I agree with every word of that.
Thank you.
So I was going to go to Merrick's, and if you'll forgive me recognising it, I imagine it's very familiar. Just the outline facts. This was a class claim brought on behalf of consumers alleging an overcharge by MasterCard, and the overcharge itself was levied on retailers. It was a form of banking charge. And the argument on behalf of the class was that retailers had passed that charge on to their own consumers. So Sainsbury's or whoever it was charged money by MasterCard. Sainsbury's imposed that charge on its consumers. And the tribunal had refused certification. The Court of Appeal had allowed an appeal, and that was further appealed to the Supreme Court, and the Supreme Court upheld the Court of Appeal's approach. And I'd like to show you, please, page 172, which explains a little bit about what the issues were. And I can take this part quickly, but it is, I hope, helpful context. If we look, this is from the judgment for the majority of Lord Briggs. If we pick it up just above letter B, the refusal of a CPO was because the claims were not suitable to be brought in collective proceedings. The first reason was they were not suitable for an aggregate award of damages. The second was that Mr. Merrick's proposals for distribution did not respond in any way to the compensatory principle. In other words, that you would get exactly what you had lost. Sorry, my Lord, I see you.
Which paragraph?
I'm so sorry. I was on page 172 under tab 6,
Thank you very much.
and I was reading sort of from around point letter B.
Yes, I've got
paragraph
it.
31. Thank you. And then Lord Briggs observes this first reason requires some unpacking and explains that there was what I'm calling a top-down methodology for working out what consumers had suffered by way of overcharge. And you'll see just below D, I just see you're having the same file problems I was having.
No, these files get overfilled and they fall apart. But don't worry. Carry on.
Thank you. And it explains the methodology included dividing the retail goods and services market into some 11 sectors, seeking to establish the degree of merchant pass-on in each, and then deriving a weighted average across the retail market as a whole. Expressed as a fraction or percentage, that average could be used to estimate the amount of overcharge passed on to consumers. And then you'll see in 32, the tribunal concluded that there wasn't sufficient data for this. And then at 33, the CAT's second reason is self-explanatory. When a class is constituted by all consumers who, during a 16-year period, purchase goods and services for from one or more of the 500,000 or so merchants which operated the MasterCard scheme, it is obvious there will be wide divergences in the impact of any overcharge upon them. Viewed individually, even if all of them will probably have suffered some loss, coming back to that probably, because of the virtual impossibility of a consumer entirely avoiding a merchant operating MasterCard schemes. And then at 34, the CAT regarded it as axiomatic, in accordance with the basic common law principle that damages had to be compensation for loss, that if an estimation of aggregate damages was adopted which was not itself based on an assessment of individual loss, that was wrong. And that was what was overturned in the Supreme Court. And I want to show you some of the reasoning. And we'll start with the majority, but with hindsight, we can see that the minority explained more fully what was meant by these words. If we can turn to page 181, this is Lord Briggs, paragraph 58. Another basic feature of the law and procedure for determination of civil claims for damages is, of course, the compensatory principle, as the CAT recognised. It is another important element of the background against which the statutory scheme for collective proceedings and aggregate awards of damages has to be understood. But in sharp contrast with the principle that requires the court to do what it can with the evidence when quantifying damages, which is unaffected, the compensatory principle is expressly and radically modified. Where aggregate damages are to be awarded, Section 47C of the Act removes the ordinary requirement for the separate assessment of each claimant's loss in the plainest terms. And then it goes on and says, moving away from the general background of law and procedure, the following points need emphasis. The Act and rules make clear, subject to two exceptions, the certification process is not about a merits test. Then it explains that is subject to the jurisdiction for summary judgment, which of course is what's happened here. And that's the majority's view. And then the minority, Lord Briggs and Lord Sales, who dissented on a point we're not concerned with, also...
You said Lord Briggs and Lord Sales. I think...
It's Lord Leggett and Lord Sales. I'm so sorry. Yes. The judgment is in the name of Lord Sales, but it was also Lord Leggett.
Lord Sales and Leggett. Yes.
Lord Briggs was the majority.
Yes.
Thank you, my lord. So there is a dissent on a topic where they disagreed with the majority, which we are not concerned with. But what we are concerned with is where the minority addressed further the same issue that Lord Briggs had addressed. And we can see this at paragraph 100, page 190, please. And you'll see, just before the part that's been sidelined, just for context, this is about aggregate damages. 93. Second innovation is section 47C2 of the Act, which we've already seen. You'll see at G, this involves a departure from the normal compensatory principle, where the object of an award of damages for a civil wrong is to put the claimant as an individual in the same financial position as if the wrong had not occurred. It is clear that section 47C2 is intended to serve this purpose. A provision for aggregate damages may, however, go further and serve an additional purpose. It may also permit liability to be established on a class-wide basis without the need for individual members of the class to prove that they have suffered loss, even though this would otherwise be an essential element of the claim. And then over the page, in the second line, an aggregate damages provision may dispense with this requirement by permitting liability towards all the members of the class to be established by proof that the class as a whole has suffered loss. And then their lordships return to this theme later at page 196 under the heading of suitability this time. In determining whether the claims sought to be combined in collective proceedings are suitable to be brought in such proceedings, one of the matters specifically identified in Rule 792 is whether the claims are suitable. In some cases, this is likely to be critical. As we noticed earlier, the potential for an aggregate award of damages is a major innovative feature of the collective regime, which, when available, has substantive legal effects. Such an award dispenses not only with the legal requirement to calculate damages on an individual basis, but also with the legal requirement for the claimant to prove an individual loss to establish liability. It allows a group to prove a claim, even though individuals within the group might well not be able to do so. And then finally, page 202, this time dealing with distribution. In other words, what happens if an aggregate damages award is made? Paragraph 149. We think it clear that under the legislative scheme, where an aggregate award of damages is made, that award is the means by which compensation is achieved. That is to say, by providing compensation for loss suffered by the class of represented persons as a whole. As discussed earlier, Section 47C of the Act dispenses with a requirement that would ordinarily apply to undertake an assessment of the losses suffered by individual members. How such an award of damages is distributed is a further and separate question. There is no necessity at that stage to try to estimate loss, only to adopt a method of distribution which is fair. Now, so what this minority judgment really does is, in fact, explain in greater detail the point made by Lord Briggs in the majority. And we're going to see that from a further decision of the Court of Appeal in a case called Gutman, another certification decision that went to the Court of Appeal. And that is in the same authorities bundle under tab 11, please.
So in that case, the merits case, there was good reason to think that the class as a whole, who were consumers of goods in shops that used MasterCard, or retailers that used MasterCard, had suffered a loss because they'd paid more.
Well, that was the argument, yes.
And then, so you can say that the class as a whole has suffered a loss.
Yeah.
It's not saying, is it, that if you can see that there are people who probably have not suffered a loss, that they can be put into the class.
I'm coming on to exactly that point now, my lord. It doesn't deal with that, I entirely agree. But Gutman does, and that's where I'm going, if I may. And that is under tab 11. This is a decision of the Court of Appeal on certification, refusing an appeal against certification. And this is Authorities Bundle 11, page 530. And again, with apologies if these facts are familiar to you in any way, the case is about a type of train ticket called a boundary fare. And as it explains in the headnote, a boundary fare is, the argument was that boundary fares were not made sufficiently available. And a boundary fare is an add-on ticket to a travel card. If you hold a Zone 1 and 2 travel card, which covers you to, say, Clapham, and you want to go from Waterloo to Basingstoke, you have the option of buying a boundary fare from Clapham to Basingstoke, rather than a ticket from Waterloo to Basingstoke. And the complaint made by the class representative was that customers were double charged because they, in the end, bought a Waterloo to Basingstoke ticket because the boundary fares, even though they existed, were not made sufficiently available in the claimant's formulation. Now, the claim ultimately failed on its facts. The tribunal found that the class representative had not shown that the boundary fares were insufficiently available. But what we're concerned with here is the Court of Appeal's analysis of the requirements for certification. And again, we need a little bit more fact before I go to the judgment. And if we can turn to page 536, please, you'll see the class definition. And you'll see it's quoted, and we really only need the first few lines before it gets very complicated. The class of persons whose claims are certified includes...
Which paragraph?
I'm so sorry, paragraph 10 on page 536. In the indent, it quotes from the class definition. And I'm going to take one short point from this rather complex formulation.
Page 5, I see.
536. Forgive me if I didn't say
That's
so.
right, I've got different page numbers, it seems.
Tab 11, 536.
Yep.
Class definition. The class of persons whose claims are certified includes all persons who at any point during the relevant period purchased or paid for a rail fare which was not a boundary fare or a fare for the portion of the journey from the last station covered by their travel card. Now, it's really complicated, but what it amounted to was anyone who had failed to buy a boundary fare for whom a boundary fare might have been applicable. The defendants objected on many grounds, including the fact that there would be people who had good reasons for buying a boundary fare or were sufficiently aware but had nevertheless chosen not to. But that argument failed, and I'm going to show you some of the reasoning, and the judgment is of Lord Justice Green. And could we start, please, on page 539, where we're back to section 47C2A at the bottom of the page where the sidelining is. Section 47C2A is quoted again. When the power is exercised, the focus of the CAT is not therefore upon sums lost by individuals. The section does not explain how otherwise damages are to be calculated. Nevertheless, it is clear that this is by reference to the total aggregate damages flowing from the breach. This is described as a top-down approach to be contrasted with the traditional bottom-up approach, which would apply if the power is not exercised, whereby the loss sustained by each individual claimant flowing from a breach is assessed and made the subject of an award. The evidence needed to calculate top-down damages is intrinsically different to that needed to assess bottom-up damages. How an aggregate award of damages is to be divided up as between the class is the subject of the later distribution stage following an award. And if we go over to the next page, one of the arguments the defendants made was essentially that section 47(2) C2 covered the calculation of damages but not liability. So that obviously took them directly to the question of the meaning of the dissent in Merrick's. And in a nutshell, the Court of Appeal held that the dissent in fact expressed the true ratio of the judgment. And if we see at 31, pass on is relevant to liability. If a claimant has passed on an unlawful charge to its customers, it might have suffered no loss, even if it was the direct victim of a cartel or other unlawful conduct. The Court of Appeal in Merrick's held the issue of pass-on was capable of leading to a conclusion the claimant had suffered no loss, but was nevertheless an issue that could be aggregated. And there they quote from the Court of Appeal, which it's in the bundle, but if any of it is helpful, it's this bit. A critical issue in deciding whether a proposed methodology is suitable and effective means of calculating loss to the class is to determine whether it's necessary to prove at trial each member of the proposed class has in fact suffered some loss due to the alleged infringement. Although the expert evidence must provide a means of calculating the level of pass-on of the MIF from merchants to consumers, there is controversy about whether that is sufficient to make the global loss a common issue. And then at 47, to require each individual claimant to establish loss in respect to his or her own spending, and therefore base eligibility under Rule 79 on a comparison of each individual, would run counter to the provisions of 47C2 and require an analysis of pass-on of individual consumers at a detailed individual level, which is unnecessary where what is claimed is an aggregate award. And then, if we then turn to this sidelined part over the page, you'll see the unsuccessful argument of the appellants, which were the appellants were the defendants. The claim had been certified. The appellants further argue section 47C(2) does not in its language refer to liability, but only to damages. Read naturally, the provision is limited to the size of an award of damages made in favour of an individual against whom a breach of duty has been established. We disagree. It is common ground that quantum should be calculated so an award of damages does not overcompensate. Section 47C(2) does not rewrite the constituents of tort to remove liability issues. It merely permits those ingredients to be established, deploying different top-down evidence. In determining quantum, therefore, the CAT necessarily ensures it excludes from the calculation those who fail at the liability stage, and the methodology must at some point include a device for winnowing out no-loss members of the class. I'm just pausing to emphasise that because I'm going to be coming back to it. When this methodology is applied, it necessarily traverses the boundary between recoverability and non-recoverability. These are two sides of the same coin. We therefore have difficulty in understanding how an aggregate quantum exercise does not involve the CAT simultaneously determining liability for the simple reason that in fixing the outer parameters of quantum, it is also drawing the line between liability and non-liability. The language of section 47C(2) is consistent with this. It creates a power for the CAT in determining what is recoverable to apply an aggregate approach. The converse of recoverable is irrecoverable. The exercise of determining aggregate recoverability necessarily entails excluding categories of consumer who should recover nothing. In addition, section 47C(2) must be construed purposively, ensuring the provision is effective. And then my Lord Justice Green repeats the principle of effectiveness. Procedural and evidential rules must not make it practically impossible or excessively difficult. And then, if we go just about 6 to 7 lines down, he says, it is a defining feature of opt-out litigation. The class representative does not have to engage with individual class members until the distribution stage. One thing I hesitate, I paused over those words, device for winnowing out, because one of the things the PRS says in its skeleton argument is that that device needs to be provided at the stage of certification. But I'm going to show you it's clear from the Gutman judgment itself that that was not the case in that claim. And we can see that by turning on now to another issue unsuccessfully raised by the defendant appellants at page 554. And it's paragraph 70. We turn to the second ground of challenge, boiled down to bare essentials that can be summarised in the following way. The expert methodology for the class representative took as a starting assumption that no rational consumer would wish to pay more than was necessary. This enabled the class representative to devise a methodology that ignored consumers who did not wish to purchase boundary fares and certain types of journey. In the 71, the appellant argued that the CAT erred in approving this assumption. There were a range of categories of situation where passengers freely and deliberately chose not to use a travel card. So the argument was that the class representative had just aggregated anyone who had not bought a boundary fare, and there was no individual consideration of the fact there may be individual reasons for this. In other words, that those are people who might properly be outside the class. And indeed, the defendant appellant's argument failed, and the CAT said at 78, at page 556, in argument, the appellants raised the
The Court of Appeal said that. Is that right?
Yes, I'm sorry, did I say CAT? I think
Yes,
I did.
you did.
Forgive us, thank you. No, we're in the Court of Appeal's judgment. Yeah. Thank you, my lord. Page 556, paragraph 78, where the argument failed again. In argument, the appellants raised the spectre that absent a detailed methodology to deal with these matters, there was a real risk that any order for damages would be unfair to the defendants and would overcompensate the class. We disagree. This argument would only hold water if the CAT was unable to make adjustment at trial to take account of issues the defendants prevail upon. However, the CAT is alive to the need to do just this so as to avoid the risk of unfair compensation. In other words, that no loss members of the class and their journeys, very importantly, could be winnowed out, because that class was simply a class of people who had taken journeys. It may be people who took 1, it may be people who took 20. But the issue was their failure to buy a boundary fare due to the alleged failure on the defendant's part to make them sufficiently available, or did they have some other reason? So I want to sum up what I say these cases show. Firstly, that liability in a class claim can be established top-down. Secondly, there is no need in so doing to establish the liability of individual members. Thirdly, it's no obstacle at this stage that there may be class members who end up with no claim. Whether that turns out will depend on the tribunal's findings, applying a top-down methodology. But importantly, this is not a claim like Gutman, where the size of the damages depends on the number of members of the class. We're talking about a pot of black box royalties. We don't yet know its size, that's been something of a moving target, but it doesn't depend on the number of members of the class, it depends on the amount of undistributed royalties. So it will actually make no difference to the size of that pot.
I'll just check I understand that. The undistributed, the black box royalties at the moment are distributed. You say they're distributed in
Yes, sorry.
unfair and abusive.
Yes, that's right.
So when you say the size of the claim is the size of the undistributed royalties, that's not
I
what you
misspoke.
mean.
I absolutely misspoke.
So what is the size?
The size of the claim is the amount of black box royalties that should have been paid to songwriters as a whole.
As opposed to publishers.
As opposed to publishers.
Yes. But how do you have to have some methodology
We do.
For identifying that. And did the CAT say that they accepted that was a methodology that was arguable? Or
No, the CAT rejected the methodology that was then advanced.
That's what I
And I'm
thought.
about to come to that.
Right. That's a separate point.
Yes, it is. It is. And I'm making what I hope is a narrower point. I made it badly because I misspoke, as you said. The claim concerns the black box royalties that should have been paid to songwriters as a whole.
Now that should, I mean,
Yes?
we'll no doubt come on to this. That requires identification of what would have happened in a better world. What's called the counterfactual.
It does.
And I think the CAT had some queries about the counterfactual.
It certainly did, indeed, and I'm going to come to that. It said that the class representative at that stage had not advanced an adequate counterfactual.
Yes.
So
it's a bit of a oversimplification to say the size of a claim. We know what the size of a claim is. We don't actually know at all what the size of a claim is. That probably wasn't quite what you said.
Whether or not I said it, let me be careful and get it right this time.
Okay.
The size of the claim is the amount of black box royalties that should have been paid to songwriters and were not.
Yes.
And the CAT accepted a very indicative high-level figure of 200 million for that figure.
No, I don't think it did.
Sorry, for the whole black box. I'm sorry,
Yes,
that was the whole
black
black box.
But
box.
that was the point.
I'm so sorry, you're right. I said I would avoid misspeaking and I immediately did.
Sorry to interrupt, but that's not even for the whole black box. So 50 million was the whole black box. 200 million related, the 200 million sum, the difference, relates to monies advanced by foreign collecting societies to record companies, which sums are not within control of my client. So I just wanted to make that clear.
We're going to come to that point if it arises later, but let me try again.
The size of the claim is the amount of black box royalties which on your case,
should have been paid to songwriters.
should have been paid
Yes.
to songwriters,
Yes.
were in fact paid to publishers.
Yes, that's right. Exactly right. And the amount of that doesn't, in fact, depend on exactly the number of songwriters in the class. That's the point.
Yes,
One of the objections that's taken against me is there may be songwriters in the class who, even under a lawful methodology, wouldn't get a share of that money. And that may or may not be true, but it doesn't affect the amount of that claim. It will
That
affect
depends
its
what the
allocation.
lawful methodology is,
It
which
does.
goes back to the question of what's the counterfactual that you rely on.
It does exactly that. It
But it
does.
doesn't just depend on that, does it? Because it's not an entirely straightforward passage to understand. But in the case you've just shown us,
In Gutman,
Gutman, it recognises that, in fact, there may be people who haven't suffered a loss,
Yeah.
who need to be winnowed out.
exactly. But it says that.
And so, although it talks about the top-down approach, it then says, but you can then look to see what people have actually, as I read, you look to see what people have actually suffered.
Or rather, you look to, and
Or
this
at least to see if
my
there
lord,
are people who have not suffered any loss and exclude them.
well, I'm hesitant to put gloss on what my Lord Justice Green said here. And the issue that my Lord has identified is evidently one on the face of the judgment. But as I respectfully submit, what is intended here is some form of adjustment can be made at trial to the top-down methodology to reflect this. But I don't want to put words into my Lord Justice Green's mouth. As it turned out, the trial was determined without having to approach this issue because it was dealt with on essentially a preliminary issue. So this was never actually explored.
So there was no abuse, wasn't it? No unfairness.
There was no abuse. On the facts, there was no abuse. So it went no further than that.
This relates to one of the points you summed up from the authorities.
Yes.
Which is that there's no obstacle that there may be class members with no claim.
Yep.
But don't you have to add to that the provided that the CAT will be able
Yep.
to make some adjustment at trial?
I do, but the point I was trying to get to here was it wasn't suggested in Gutman that needed to be available at certification.
No, but if it can be shown at certification, if you can't show at certification that there is a possibility, there is a way in which the CAT can do that, and that would be a fundamental problem, wouldn't it?
Well, I think it would. I'm going to try and duck the question if I possibly can by saying that would be quite fact sensitive, in the sense that if you could just not conceive of any way of making an adjustment, that would be a potential objection to certification.
Turn it around, don't you have to provide some way in which it can be done at the stage of certification to show that it is something that is possible?
Well, at this stage, what we need to show, in my respectful submission, is that there is a loss suffered by the class as a whole. Each member of the class has a right to what we would call a non-abusive methodology. Each member of the class has a right to injunctive relief to ensure that the methodology is lawful going forwards. As part of that methodology, the methodology adopted will indeed determine which members of the class are, in fact, entitled to damages as well as an injunction. And at that stage, there is no difficulty with either winnowing out or dealing with it at distribution.
You need some rule for doing that.
Yeah, yes, you do.
Because you need to be able to, because winnowing out requires there's some way, even in principle, of taking out the no-loss people.
Yeah, but the principal concern is to avoid overcompensation. This is what was said in
But
Gutman.
how do you do it? What is the rule for excluding the no-loss people?
Well, this would be part of the top-down methodology that was adopted.
But what is it?
Well, that's where can I take you back to the judgment?
In this case, what is the top-down methodology?
Well, I need to show you exactly what was said about this in the judgment, because the blunt answer, my lord, as I alluded to in the opening, is we don't have one to put before you today. And I have to face that, absolutely. I can't pretend it's otherwise. But can I show you the judgment, please? It's under tab 7. And it's at 77, where the counterfactual that was advanced by previous legal team is addressed. And it says at 77, we have in our mind, sorry, it's at page 110. And this is where the genesis came from the adjournment application. We have in the forefront of our mind, we're only wielding a broad axe at certification stage, and due allowance should be made for imperfections in the methodology which can be addressed going forward. But as yet, the PCR has not, even in general terms, identified a plausible approach to how it might estimate the sums that should be paid to writer members in the counterfactual. It follows the PCR has not identified a sufficiently credible or plausible method of how damages are to be assessed. And then the tribunal says, had the application for strikeout and summary judgment not succeeded, we would have been receptive to the submission that in the light of further information that has been provided by the PRS during the course of this hearing, between the 13th of February, which was the start of the hearing, and the 16th of June when it was resumed, the PRS should have a further opportunity to formulate its counterfactual in the light of its methodology. In the light of this information. And then it says we're not clear the defects can be easily fixed. This legal team came in, asked for an adjournment, which was refused. I'm obviously not here to appeal that. But what that means, though, is obviously I'm not in a position today to advance fresh evidence about what that methodology.
But could you not even describe it? I mean, you've had now since August last year when this decision was made.
Well, I'm going to try.
We've got an appeal process.
Yeah, I'm going to try. Obviously, I have to be careful because Mr. Mitri will rightly complain if I try to give evidence from the bar. So I'm going to do my best, though, with what this. As I've already said, we're not going to say that PRS has to individually match every one of the royalties. I've already explained that. That would be a form of bottom-up methodology, where one has to look at song 2 and work out exactly what happened. There are 165,000 songwriters. Mr. Rowntree is the writer of hundreds of songs. This would be a vast and it would be a rolling exercise. But our case is that what's needed is a top-down methodology that can look at where the errors have come in, where the royalties have gone unpaid. And that could no doubt involve some kind of sampling exercise, just as the PRS does on its matched royalty methodology. And it may only need to do this from time to time rather than on a continuing basis. It may well be that, like matched royalties, breaking down the data into different categories would be helpful. There might be differences, for example, in the kind of publisher. So you might find that major publishers like Universal have better records for themselves and for songwriters, or not. There may be differences in the kind of performance. So you heard me, I showed you earlier Mr. Arber's evidence that a channel like BT Sport uses what he called repetitive small breadth total repertoire. Somebody must get paid when BT Sport plays the Champions League theme. Although I think actually that was written by Handel, that might not be a good example. But all of this would be a matter of expert evidence. Looking at the PRS's own records, we won't get that to disclosure. Obviously there is asymmetry of information now, but looking at a sample of how the royalties are actually allocated and how in fact the data errors creep in could be the basis for an extrapolation that would cure the underlying bias, or indeed demonstrate that it didn't exist, in which case that would be the end of the claim.
I'm not sure I follow that with respect. The PRS, in relation to the works, trying to identify the works that have been used, so that's one form of problem. They've already got all of these methods for trying to do it.
Yeah.
There's census, there's by analogy and so on.
Yeah.
Sampling by analogy. So they are already doing that. So what's the further...
To look
and equally, there is no complaint in the proceedings about those procedures.
Oh, yeah. None at all.
So what's this further...
The further step would be
or whatever it is.
carry out a similar exercise in respect of the unmatched royalties to identify whether empirically the complaint that there is a bias against songwriters is actually right.
But they don't know because they're unmatched.
No, but it would be a question of doing it.
Therefore, sorry, let me just finish.
Sorry,
there's therefore an absence of data about all of those things. So there isn't data which you could then use in order to sample where it's gone wrong, is there?
Well, the data that exists is exactly the data of the unmatched royalties, to look at them and see why has the royalty not been paid out and whether the error is in fact soluble. That would be the issue, not for the entire
But these are complaints about whether they're properly using their procedures to match, aren't they? Because if they were able to do it, then they would be matching.
No, my lord, the proposition is you would take the data set of unmatched royalties and look at a sample to try and identify what kind of error had given rise to the non-payment and whether in truth there were more songwriter errors than publisher errors. It's really not more than that. I mean, obviously there's a limit to what I can do without trying to give expert evidence, which I'm obviously in no position to give. But our broad proposition is that the law allows us to do this through top-down methodology, even though there may be members of the class who end up with nothing.
Just take there's the two halves. Take the unidentifiable song half.
Yeah.
And per our discussion earlier, that affects songwriters and publishers equally.
Or potentially.
Well, difficult to see why not if you simply don't know what song has been played. There would be a publisher and a songwriter or songwriters for that song, none of whom have been matched. So what you're really arguing for there is much more intense auditing of, let's say, what's played on television in the scenarios you mentioned, and then making analogies or something else from that. But that is just making the matching process better. But the people who can complain about that not happening is everybody. It's not a particular portion of the PRS members, is it?
I'm not actually arguing for an improved matching process. I'm arguing for some kind of sampling or analysis process that shows what the real balance is between songwriters and publishers who've lost out through unmatched royalties, so that a better method could be adopted going forward. And again, if I can clarify, I'm not suggesting that this would have to be a permanent feature of the PRS's regime. Rather, at the moment where we have almost a no method, it's just paid out pro rata, one could identify the structural bias that we're talking about and adjust for it. That's the argument.
But does this get you no further than establishing as a matter of fact at trial the assumption that is being made at this stage?
Not necessarily. That would be a good start. But then if you identify if you can identify how the bias has arisen, assuming that it has, you can then propose a method to cure it. But this is where I'm starting to fear I'm trespassing beyond what I can reasonably say as an advocate. And I have to face up to the fact that I'm not here with you with an expert report that really answers these questions. It's a function of the way these proceedings have got this far that I'm just not able to do that.
Can I just pick up my lord's point?
Of course.
Where you don't know what song has been played. If you don't know what song has been played, is this right? No amount of interrogation of the data will tell you
No.
how much of that should go to songwriters and how much should go to publishers.
That's right. That is right.
And just stepping back from the detail,
right.
If you don't know which song has been played, is there anything wrong with the assumption that the universe of unidentified songs that have been played is likely in general to bear some resemblance to the universe of identified songs that have been played. So that distributing those unmatched royalties pro rata to the identified songs doesn't seem particularly unfair.
Well, there are a number of answers to that, my lord. First one is a very high-level answer, which is the proposition that has been held to be arguable, is that across the set as a whole, more is paid out to publishers than should have been, or less has been paid to songwriters than should have been.
Well, I can see that if you've got a particular song, but the data isn't good enough, your proposition is that's more likely to be the songwriter's data not being good enough than the publisher's data not being good enough. I see that entirely. But I'm having difficulty seeing how that has any impact at all on these unknown songs where no amount of looking at the data will tell you which song it was.
Indeed, and I also don't know, actually, whether that's just a small part of the overall world of the unmatched royalties, but then it would be a question to ask if there was a pattern of data errors within the identifiable ones, whether it was also relevant to consider that in respect of the unidentifiable ones by extrapolation. But all of that would be argument for the expert methodology and sits under the umbrella of the tribunal's finding that across the set as a whole, there is an arguable misallocation of royalties. And my lord asks questions that clearly are important in the granularity, but again, I'm hampered by my lack of methodology in front of you today.
Okay, thank you.
So if I could now just turn to the tribunal's judgment and attempt to cash out those points. If we turn, please, to core bundle under tab 7, page 104. And the first point is really, I think, probably the central point. Paragraph 60. The PCR describes the unfairness as not paying royalties owed to songwriters. However, the writers, and for that matter publishers who receive black box royalties as a result of their being distributed, have no prima facie entitlement. And then it says, other than receiving royalties for their own works, what is promised is, what is owed to writers is only what is promised in accordance with the rules and policies. It is not contended PRS is not complying with its contractual obligations. I'm going to separate out that contractual obligations point and deal with it in a minute. And then it says at 61, I think the same point, the people who are potentially owed black box royalties are those whose work is performed and for various reasons cannot be identified and paid. However, the class is not drawn to describe those people. It's all writer members. And our answer to this, which I've really prefigured, is that what the class as a whole is owed is the existence of a lawful distribution system and its proceeds. And our case is that that would be a system that lacks structural bias. If we're right about that, that means that there is more black box royalties that should have been paid to songwriters. And if an unbiased method was adopted, there would have been more money for songwriters. And the question of exactly who suffered the loss would be settled through top-down methodology. So that is the sense in which the songwriters are owed. They're owed a lawful methodology and they're owed the proceeds of it. I accept, I already have, that it may be that not all members of the class will get damages. Under a lawful methodology, there may be members of the class that will receive nothing. In light of that, it may be the class definition will be narrowed or the matter could be dealt with at distribution. But we will not know the answer to any of those questions until, if remittal takes place and disclosure takes place, there is expert evidence to assess it.
But the expert evidence isn't going to be able to decide those questions or inform those questions, is it? Because if there's a lack of data, it's not going to turn up on disclosure.
No, indeed, what it can do is look at the faulty data that there is and identify the extent to which this demonstrates errors in favour of songwriters. That's the issue. But rather like I showed you with Mr. Rowntree's own evidence. Now, can I go back to the point about contract, which is in paragraph 60, where the point was made, it's not contended the tribunal is not complying with its contractual obligations. And with respect, that is not an answer. It's well established that an arrangement of this kind can be governed by contract but still be in breach of competition law. And I'd like to show you one authority for that proposition, please, which is also useful later on. And this is the European Court case of BRT, and it's in Authorities Bundle 2 under tab 19. And there are some complexities in this that we can cut through very quickly. And it's page 948, please, I want to start. And this is under the heading Facts, just the first two paragraphs. (948). And you'll see this is about the Belgian equivalent of the PRS. The Belgian Association of Authors, Composers and Publishers, referred to as SABAM, is a cooperative association governed by Belgian law with the object of exploiting, administering and managing, in the widest sense of the terms, copyright and so forth. SABAM concluded standard form contracts with the composer Mr. Davis and with the songwriter Mr. Rosenstraten in 1963. Under those contracts, they're signed and transferred to SABAM their copyright in all present and future compositions, of which they will be whole owners, and all present and future rights as performers and producers of gramophone records. So it was a cooperative, it was a mutual society like the present, but it was governed by contract. And then if we move on to page 988, we can see the judgment, which explains what the issues were in that case. And if we look at the bottom of the page, paragraph 3, by the first question, it is asked whether an undertaking which enjoys a de facto monopoly in a member state for the management of copyright abuses its dominant position by demanding the global assignment of all copyrights without drawing any distinction between specific categories. And then by the second question, it's asked whether an abuse of that dominant position can consist in the fact an undertaking stipulates an author shall assign his present and future rights, and without having to give an account of its action, the undertaking continues to exercise the rights assigned for 5 years following withdrawal. So very different facts, but structurally the same kind of complaint by someone who's contractually using the SABAM about the way it distributes. And at 5, it's apparent from the order for reference the National Court, having found the undertaking in question, in fact exercised a quasi-monopoly within the Belgian territory and consequently a dominant position. And that, of course, we would say is the same as this case. And then paragraph 6, which no doubt was the inspiration for the formulation in this case, according to the terms of what was then Article 86, an abuse must be regarded as consisting in directly or indirectly imposing unfair trading conditions. And then, just while we're here, because it will save time, at 10, for an association to effectively to protect its rights and interests, it must enjoy a position based on the assignment in its favour by authors of their rights to the extent required for the association to carry on its activities on the national scale, necessary scale, Consequently, it is desirable to examine whether the practices in dispute exceed the limit absolutely necessary for the attainment of this object, with due regard also to the interest of the individual author. And then it says, for this purpose, a compulsory assignment of all copyrights, present and future, with no distinction, may appear an unfair condition, especially if such assignment is required for an extended period. And then at 15, it must be concluded that the fact an undertaking entrusted with exploitation of copyright and occupying a dominant position within the meaning of Article 86 imposes obligations which are not absolutely necessary for the attainment of its object and which thus encroach unfairly upon a member's freedom to exercise its copyright can constitute an abuse. And I'm coming back to that very soon as to the substance of it. But the short point I make really is this demonstrates that a finding that this is governed by contract really is no answer to our contention that the inherent bias in the system is abusive. And if I could now turn back to the judgment, please, under tab 7 of the core bundle.
I have to say, I didn't read the tribunal as saying that, but it may be. I thought the point they were really making there was that when you talk about the amounts being owed to you in inverted commas, it can't mean you're not getting the amounts to which you're contractually entitled.
Yes.
So that's not the complaint. But I don't think the tribunal was taking a narrow legalistic point of that kind. It was saying that there's an issue as to whether, as a matter of substance, it can be said that amounts that should have gone to the writers were not going to them. So I don't, for my own part, read it as taking that narrow point, that because there's a contract, there's no infringement of competition law.
My lord, you're right. You're right. It's not making that narrow point. But the BRT case is nevertheless important here to demonstrate that the entitlement that can arise under the law of abuse of dominance may supervene above contractual entitlement. So perhaps I just didn't formulate it as accurately as I should have. And our case is what the songwriters are owed, to use the tribunal's words, is the proceeds of a lawful policy, a non-abusive policy. That's the issue. And then if we go back then, please, to the judgment, I was going to turn to paragraph 62, which is, so it's core bundle, tab 7, page 105. And this is really a short point where the tribunal says, it follows that no reasons are advanced which are capable of supporting the contention that the members of the class share the common feature of being owed black box royalties. And we interpreted that as a reference to the commonality test, which forms part of the requirements of certification. And we said so in our application for permission to appeal to the tribunal, and it didn't disabuse us of that idea. But again, in our respectful submission, there is a very short answer to it. All the members of the class have the common feature of being subject to an unlawful distribution policy, a policy which is in breach of competition law. The class as a whole is owed more by way of royalties on aggregate. Too much has been paid to publishers and not enough to songwriters. And of course, as I've already said, there may be winnowing out, there may be adjustment of the class, there may be distribution. But it's perhaps helpful just briefly to return to the Gutmann judgment, which establishes that the interests need not be identical. What matters is the question. Could we go, please, back to the authorities bundle 1 under tab 11?
Can I just, before we look at that, my lord, looking at the tribunal's judgment, paragraph 63, they say you could have had lots of distribution policies, and some might be better than others. You could have given it all to a charity. Would you have a complaint if the PRS had given unclaimed royalties to charity?
I might do. I might well do. But the complaint I do have is that it hasn't done that at all. It's taken one pot of royalties, it's got two types of customer, and it said it really doesn't matter. The PRS's case is it really doesn't matter which we pay it to. Rather like a client at the end of litigation saying, I've got solicitors' bills and council's bills to pay, and as long as I pay the full amount, it really doesn't matter who gets the money. So where what we have is not a disbursement to charity, but an undercompensation in favour of another group, in my respectful submission, that is abusive. I mean, one could have characterised it as economic discrimination. I mean, that's not the way it's pleaded, but it's just unfair to say we're going to distribute it, but you just don't get your proper share. That's really.
But that assumes there is a proper share. The point about the charity example is if you couldn't complain if all the money was given to charity, that illustrates what the tribunal means by saying you're not owed these monies. You couldn't. No individual could assert a claim to the monies precisely because nobody can identify whose monies they are.
Well, I think my client might well have complained if they had just given it all to charity. I'm obviously just thinking on my feet rather than on instructions. But he might well say, well, look, wait a minute, those are my royalties for song 2, and I'd like the money. Not you're free to give it to whoever you want. Well, I've illustrated that through his witness statement, where he's looked at part of the database and shown that it seems on the face of it the royalties have gone astray. So he might well say, look, if you've failed to pay me royalties on song 2 because you've attributed it to Blur rather than Mr. Rowntree, Mr. Coxon and the others, then yes, I'd like my money, thank you very much.
But that's a different sort of claim. That's a sort of claim saying that really you ought to be able to match those royalties to me. It's my song, and you've just got the name wrong, and here's the right name, and now you have to pay me. And he says he tried to do that, and he didn't get anywhere. But this claim doesn't seem to be a vehicle for saying that money's actually mine. But this claim is a vehicle for saying nobody knows whose money that is, but we should have more of it than we collectively should have more of it than we've got.
It's a claim that says you've got a problem to distribute this money. At the moment, you're distributing it in a way which is biased against one of your two groups of de facto compulsory members. We say that the appropriate and lawful methodology would not suffer from that bias. I accepted in the course of my submissions it would still have to be top down, not that the PRS has to.
No, this is a different point. I understand the top down.
Yes,
point.
sure.
This is a point where the tribunal says none of the class are actually owed these monies, and as what I understand by that is that the only person who is actually owed the money is the true songwriter and the true publisher of these unmatched royalties, but nobody can identify that. So nobody else, the class as a whole, can't say that's our money.
Well, the class as a whole can, in the sense that the way the argument is put, my lord, for better or worse, is to say, looked at on an aggregate basis, too much money is being taken, not enough money is being given to songwriters. As a whole, they are getting less than they should as a whole if a non-abusive method was used. Therefore, at an aggregate level, there is a loss. Yes, and that is the claim.
Yes. Okay.
So in one sense, it's less ambitious than saying, and the problem is you haven't identified every single song 2, song 3 or song 4. But that is the claim.
Yeah.
And I was going to just show you briefly a passage from Gutman on commonality. And it was in the Authorities Bundle 1 under tab 11 at page 545. And this is quoting with approval from the tribunal, which itself is summarising some Canadian case law. But luckily, despite that framing, it's a very simple paragraph.
Sorry, which paragraph did you say?
It's page 545, and it's indented as 107 from the quote from the tribunal, and then it's subparagraph 3, which, if I can spare the pain, is approved. A common issue does not require all members of the class have the same interest in its resolution. The commonality refers to the question, not the answer, and there can be a significant level of difference between the position of the class members. Therefore, the question may receive varied and nuanced answers depending on the situation of different class members. And our submission is that that requirement is amply met by the aggregate failure of the PRS to pay songwriters the appropriate amount. With that, I was going to turn very briefly to ground two. I don't know if it's your practice to take any kind of mid-morning break.
We don't in this court.
No.
No.
Right. I can deal with this very quickly because actually, in truth, I've covered all of the ground. And if we go back to the tribunal's judgment under tab 7 at 62, the tribunal's own reasons are very brief. And it says, it's the next sentence of 62. No coherent reasons are advanced to support the position that notwithstanding the members of the class are not owed these royalties, and I've already taken issue with that to the extent I can, it is unfair and abusive not to pay them. And really, you already have my point on this, which is a distribution system with an inbuilt bias is at least arguably an unfair trading term. And I also said in opening that the PRS hasn't actually sought to advance a justification for it. And I put it no higher than that this is arguably a breach of Article 102. And I'm afraid, with apologies, we are going back to Gutman. I should have asked you to keep it open. I'm so sorry. It's tab 11, again, of the authorities bundle, where Lord Justice Green synthesises the law, including the BRT case that I've just shown you. And at paragraph 93, page 560, he's talking about the unfair prices and unfair trading conditions. And unfair trading conditions is what we're concerned with. The law relating to abuse is concerned with consumer unfairness, because when an undertaking is dominant, it's by definition freed from competitive shackles which otherwise incentivise and discipline it to maximise consumer welfare and benefit. Then it says, this is why the laws most worldwide prohibit abuse of dominance, which include the prohibition of some form of unfair terms and prices. There is no single definition of unfairness, and then it cites Mr. O'Donoghue's textbook. The test includes asking whether the term is reasonable, bearing in mind the legitimate interests of the dominant undertaking, its trading partners and consumers. It is commented the reasonableness test seems vague, but a more developed definition from the case law is one which involves two stages: analysis of whether the disputed term serves a legitimate purpose, and if so, whether it is proportionate. And I showed you the BRT case, which is in fact also referred to in the Gutman judgment. And our case is really very simple. There is a structural bias. The PRS says nothing about, by way of justification for this rule, or why it adopted it. And instead, it says it doesn't matter. And I just will show you that, if I may, in the supplementary bundle, under tab 2, at page 60. And this is where they're really saying that this is just not capable of being an abuse. It says it may be a 53A. It may be that.
What is this document?
I'm so sorry. This is the PRS's response to the CPO application. And a similar point is made in their skeleton for this court, but perhaps not in quite such colourful terms. It says, the 53A, consider other possible statistical correlations, because it's saying, well, so what if there is this bias? It may be that men are more affected by data errors than women. It may be that data could show, there are regional differences. And then it says at 54 in the third line, this is an absurd and fanciful basis for a composition claim. But in our respectful submission, it's the very opposite. If we step back again and ask ourselves what is going on here, we have a compulsory trading partner, the PRS. It is a de facto monopolist. People like my client have no realistic choice but to use it. It has two groups of users, songwriters and publishers. The tribunal found it was arguable that royalties were paid to one that should have been paid to the other. In our respectful submission, it is at very least arguable for the purpose of certification that this should be tested against the evidence. We've cited the various cases that say one should be slow to strike out without the evidence. Here we are very far from having the full facts. We've had no disclosure. The size and even the makeup of the black box has shifted several times, as the judgment shows. We don't even know how big the discrepancy is between songwriters and publishers. And we've had no explanation from the PRS of why it adopted the rule. In our respectful submission, the appropriate course was for that to go forward to be tested at trial. Would you just please give me a moment? So, unless I can assist further, those are my submissions.
Are you proposing to deal with the respondents?
Oh, I can deal with that now, of course.
I mean,
yes, no, with pleasure. I assumed you'd prefer me to deal with it after you'd heard from Mr. Michu, but I can take it now with pleasure.
I think your instinct is right, and it's probably better to have the point developed first, and then you can answer it.
Thank you, my lord.
Can I just ask you a question before you sit down?
Of course.
This probably doesn't affect the appeal, possibly subject to the point about the respondent's notice, but supposing that there was some award of damages in this case, how would it actually be paid? What's your case on what the PRS would do? I'm just thinking about practicalities for a moment.
Do you mean how it would... I'm actually not sure I understand precisely what you're asking.
How would it fund it?
How would it fund it? Well,
It's paid out all of this money in the past.
so there are a number of answers to that question, and one is that it has a rule that sums being paid in error can be recouped. And the tribunal...
Have these been paid in error?
Well, if you pay money that's in breach of competition law, that's surely an error, isn't it? I mean, if
Well,
you
it's
pay
not
money...
my job to answer your question.
Let me reformulate that in a way that wasn't unintentionally rhetorical. If you make a payment, you presumably are aiming to do so lawfully. If you make the payment unlawfully, you have made it erroneously, unless it is your deliberate intention to make an unlawful payment, like, say, a bribe. But beyond that, the PRS, I mean, I have no idea if it has insurers. It hasn't. I don't think it's explained. But ultimately, this is about money that has been paid to publishers wrongly, and therefore the PRS can and has the ability to recoup. But in any event, my lord, that is a question for another day.
And supposing there's someone who, it turns out, a writer member who got more under the pro rata rule than they would have done under whatever rule you're suggesting, which isn't clear at the moment. Do they have to repay as well?
My lord, if I may, there are too many branches in the rabbit hole for me to be able to answer that. At the moment, there's no reason to think there would be any such person. What we're doing here is growing the pot. So the question of exactly how the PRS funds on the basis of exactly what the award is a long way down the rabbit hole. There's certainly not implicit in anything that we're saying that would be necessary.
Thank you.
Thank you very much. Yes.
Please, your lordships, I want to start by giving the court an overview of our response to the appeal, and in doing so just drawing out some key findings in the judgment below. If we turn up the judgment, please, so if we go to the core bundle, tab 7, page 97, paragraph 37 of the bundle, 37 of the judgment. It is a critical point that no complaint is made in these proceedings in relation to PRS's inability to identify the writers whose works are being performed and whose royalties are in the, I'm going to use the expression black box, so we don't accept it's very accurate, but I'm going to use it just for ease of reference. So that's a critical point. Nor is it suggested that there's anything else my clients could do accurately to match those royalties with the performances that they correspond to in reality.
Some of Mr. Rowntree's complaints seem to be about his own individual position, saying, I should have had this song and I should have had that song.
Yes.
But you say that's not part of this claim.
It's not part of this claim. So Mr. Rowntree has accepted for the purposes of this claim, and you see the tribunal's finding to that effect at paragraph 37, that no complaint is made as to PRS's inability to identify, to match the royalties in the black box with the performances that have taken place.
So Mr. Rowntree may have legitimate reasons for saying, where it says blur, you ought to be able to work out that means me and the other writers. But that's a separate, if he has that complaint and wants to pursue it, that's something entirely separate from these proceedings.
Yes, exactly, my lord. And what you will see, let me just show you some of what the tribunal found in relation to the efforts that are being made, and you'll see why no complaints being made about them, because they are with respect, sophisticated efforts that have improved over time. So my client has improved its processes over time. The tribunal, of course, had evidence from Mr. Arbour. My learned friend took you to part of his statement. But just sticking with the judgment.
And he was head of the distribution policy.
His position is, so he's Director of Operational Improvement is his role at PRS. But he's best placed to explain these matters, and he gave 3 witness statements, which were before the tribunal. And if we go to page 92, so paragraph 22 of the judgment, one of the points you'll see is that money is held for 3 years before it's deemed to be unallocated and distributed on the pro rata basis. So Mr. Rowntree spotted these errors. He's got 3 years in which to approach PRS and say, well, hang on, I found this issue. Can I please have some of that money?
Yeah.
And so this does mean we say that a member who does spot an error has plenty of time to correct the position by submitting the correct information to PRS. And then looking at paragraph 23, PRS initially uses an automated process to identify works, which matches about 90% of the works, and then uses a manual matching process. And you can see in that paragraph that the threshold for this used to be £5, but it's now been lowered to £3. So more of the initially unallocated royalties are subject to the manual matching process, which results in a further 2.5% of works being matched. And pausing here, as I'll show you in a moment, this is one example of PRS improving its processes over time, which we say is wholly inconsistent with any notion that it's behaving as a lazy monopolist that is exploiting its members. Mr. Arbour identifies other improvements over time not mentioned in the judgment. Can I quickly show you those? So in the supplementary bundle, behind tab 3, if we go to page 88, so bottom of the page, paragraph 37 describes the efforts that have been made by my client to improve metadata matching. And then if we go forward to page 92 of the bundle, you see a heading there, PRS's activities to maximise the accuracy of its records. And what you see in the next few paragraphs is a summary of various outreach programmes by which PRS aims to maximise the accuracy of its records by giving presentations and members' days and encouraging all of its members to check that their records are accurate. And then we see, if we go on to page 105 of this bundle, paragraph 103.2 at the top of the page describes, for example, PRS's efforts to check bank details. So there's an ongoing communication where it discovers that it doesn't have the right records. And if we could go back to the judgment, so core bundle, tab 7, page 91 of the bundle, paragraph 21 of the judgment explains the decision-making process. So the decision-making process in terms of distribution. And you see that there's a distribution committee. And can I just ask you to read the inset, paragraph 56, which was part of Mr. Arber's evidence accepted by the tribunal. And so what you see here is not only does the committee comprise both songwriter and publisher members, but as you would expect, decisions of the distribution committee have to take account of various factors, including the balance of cost efficiency and accuracy. And it's obvious why that is, in my respectful submission, because at some point, the expense involved in taking more and more and more sophisticated steps to match remaining unallocated royalties will cost more to members than the value of those royalties. And so that kind of nuanced decision is obviously one which is much better taken by the distribution committee than by the tribunal. And I'm going to come back to that, but it's one of the reasons why this blunt tool of the Chapter 2 prohibition is really not directed to this kind of term. Now, and I don't take you back to it, but Mr. Arber explains, I'll just give you the references. So supplemental bundle, tab 4, page 85, that when works are registered, the shares of writers and publishers are linked, and also publishers cannot register works reflecting only their own interests, and they can't allocate more than a 50% share to themselves. So, pausing here, the court can see that PRS goes to considerable lengths to distribute royalties to its members for uses of their musical works, and to ensure that such distribution is as accurate as possible. And as I've said, the PCR makes no complaint about PRS's efforts to allocate royalties to the correct members. Nor does it say, and this is really a critical point, nor does it say that there is some way that PRS could distribute the unallocated royalties according to a true identification of the works in question. It therefore accepts that there is no method for distributing the black box royalties that will result in them being distributed to the members whose works were performed so as to give rise to the payment of that royalty. Because there is no way of obtaining that information.
In a perfect world, the royalties would go to the writers concerned.
And to the publishers concerned, yes. My lord. Yes, exactly. And the important point for the purposes of these proceedings and this appeal is that Mr. Rowntree accepts that that can't be done.
The perfect world is unattainable.
Unattainable. And also accepts that more can't be done to make it more perfect. So that follows from there being no challenge to the efforts that are being made to match the royalties with the works that were performed. And that really is at heart a fundamental problem with what Mr. Ward suggested on his feet as being his counterfactual, what PRS should do. And I'll come back to that point in a moment. So it follows that PRS must take some decision on distribution which involves giving unallocated royalties to someone other than the person, writer or publisher, who earned them by having their song performed. So that is common ground. And the PCR's complaint, to cut to the chase, is that PRS should have adopted a distribution system which is different from the current distribution system. Indeed, its complaint is that PRS's decision to adopt this distribution method rather than a different one is so unfair as to be abusive. Now, Mr. Rowntree has not himself put forward any alternative distribution method and has pleaded no case in relation to this at all. Now, the closest he came in his skeleton argument. Let me just show you what's said there. So if we go to the core bundle, tab 2, page 25. He says there, one way that the allegedly unfair and abusive distribution system might be altered is to distribute black box royalties to every member in equal proportion, in which case every proposed class member would benefit from the damages sought. So that's what we have in the skeleton argument. Now, Mr. Ward didn't press that orally at all. But
I don't press that.
I'm grateful to my learned friend. I do, however, want to address it, not because it's a point that's pursued, it's obviously not, but because it demonstrates quite clearly the danger in seeking to, the difficulty in alighting on an alternative distribution method, which is not only fairer than the current one, but so much fairer that it demonstrates that the current method is abusive, which is what my learned friend has to show. Now, what that distribution method would mean, which is a flat per capita rate, is that a songwriter who has written a single song that proved to be unpopular and was played a handful of times, and who, let's say, assiduously recorded their data such that they received all the royalties, not very many, but all the royalties that were due, that person would receive the same portion of the unallocated royalties as Ed Sheeran or Dua Lipa or somebody else who is selling, whose songs are being performed literally billions of times. In other words, the unsuccessful songwriter would get a windfall, and the successful artist would receive much less than the sum which likely reflects their performances that have not properly been identified. And as to that, you'll recall Mr. Rowntree's evidence is that even very successful songwriters have data problems. Now, this is a point that the PCR, in his skeleton at least, doesn't seem to have appreciated, because he says at paragraph 31, every class member would benefit, every class member may benefit from such a so at paragraph 31, every class member may benefit from a per capita equal distribution. Now, of course, that's true as compared with receiving nothing, but it's plainly not true as compared with the status quo, where some members, the Ed Sheerans and the Dua Lipas and many more, will do much better from a pro rata, from the current policy, than a per capita approach. And that's even if the per capita approach involves taking some of the pot that's currently given to the publishers. And obviously, the comparison that the tribunal has to make is not between what happens if nobody gets anything, it's between the status quo and what the counterfactual is supposed to be. And this is why, in addition, this is really the fundamental answer to the point made that there's an inherent bias as between songwriters and publishers. That is to treat songwriters as a monolithic group. And the reality of the matter is that they're not a monolithic group. As the court put to Mr. Ward in the course of his argument, royalties are not allocated to songwriters and to publishers. They are allocated on an individual basis. And so the truth of the matter is it's wrong to look at songwriters as a monolithic group. And my Ed Sheeran example, the per capita basis, precisely demonstrates why that's so. There will always be winners and losers, and you simply can't break it down in this way. And that's really the fundamental problem with the case. Now,
but you could say, if you came to the conclusion that overall more of the missing royalty payments were songwriters' payments than publishers' payments, you could take a smaller amount for the publishers collectively and a large amount for the songwriters collectively, and still distribute the songwriters pro rata to their other payments, so that Mr. Sheeran would still do well. But since there'd be more money, everybody would do better. It's not impossible to envisage a situation in which, if the premise is made out, then the consequences would benefit it.
my lord, that is an interesting suggestion. It's not one that Mr. Rowntree has made, so it's not a counterfactual that's been put forward. And my lord, I would suggest that one of the flaws in that, or the reason, maybe perhaps the reason that hasn't been put forward, is because what it comprises is maintaining the status quo for the current distribution amount, which they complain about. So they say that's intrinsically problematic, and adding a little bit on top. And so it is, with respect, I think the reason that hasn't been put forward is because it would suffer from the very defect that they are complaining about, because it would be maintaining the status quo with a sort of top-up, as it were. So that's, I think that's one answer to that point. So it's not a point that it's not an argument that's been put to us. The second is that, of course, if that were to happen, then it may be that publishers come forward at that point and they say, well, hang on a minute, we have lots of data problems too. And I'm going to come back to this point, because although the tribunal accepted, as we must accept for the purposes of the strikeout, that songwriters are disproportionately affected, that it's arguable that songwriters...
But you don't accept it as a fact.
We absolutely don't accept it as a fact. Arguable that songwriters are more heavily affected. You can immediately see that that would be a controversial proposition. I'll come back to why that is. Controversial proposition. And in circumstances where it's being said, well, hang on, keep the status quo, the pro rata, so keep Mr. Sheeran happy, but let's take a top-up from the publisher's 55 million pot and give that to the songwriters as well. That publishers would say, hang on, we think it's arguable that we are equally affected, and so we want a collective action too, in order to affect our own redistribution. And that is why, at root, this is just not, competition law is not the right instrument to be tackling issues of this nature. It's and I'll come back to that under ground too. If you just give me
the court,
yes.
or rather the tribunal in this case, could, I suppose, invite a representative for the publishers to, or could allow a representative of the publishers to be a party, could it? As an interested, I don't know.
I think procedurally that would be
a representative, I don't know, but there may be a procedural way of dealing with your point about them being affected.
There may be a procedural way of addressing that point. But the overriding point is that, and I'll come back to this underground too, that this term is simply not unfair. There's nothing inherently about it that favours publishers over songwriters. And so if one were to, you already have the point about the efforts that are made to match royalties. If both groups were affected equally by data issues, then this would be a perfectly fair way of organising things. It's only because they say songwriters are more affected by these data issues but that doesn't help them because songwriters are not a monolithic group. Now, Mr. Ward, having abandoned the point about a per capita distribution, rightly, for the reasons, no doubt he saw that that was problematic, for the first time in this hearing, offered something else. So he said, okay, the data can be interrogated further to work out the disparity, if there is a disparity, and if so, what the disparity is. Now, there are two problems with that. The first problem is that it runs into, definitionally, the data problem. So PRS has done what it can already to scrutinise the data and to match, and there are no complaints about all of its efforts. And so, definitionally, these are performances which cannot be identified. And so it's just impossible to see how that exercise could be performed. So that's the first problem. The second problem was, I think Lord Justice Zacaroli made the point to my learned friend, which is that it actually gets my learned friend no further than the factual assumption that on which the tribunal proceeded, which is that it's arguable that there is a disparity. And our case is that even taking that factual assumption and assuming it's arguable for these purposes, the allegations are not arguable and they don't get off the ground. Now, in summary, and I want to take ground 2 first because as we have done in our skeleton argument, we think it comes logically first. In summary, as to ground 2, we say that the Chapter 2 prohibition is not a general law of consumer protection. It doesn't give the tribunal a roving brief to scrutinise all the contractual terms of a dominant undertaking and assess whether they're proportionate to a legitimate aim. It will only intervene to strike down a contractual term on grounds of unfairness, where it exploits consumers because it is arbitrary or perhaps disproportionate. And we say the fact that the PCR cannot, even now, when it's in last chance saloon before this court, identify a distribution policy that is fairer than the one chosen by the committee tells us everything that we need to know. And as to ground 1, we say that it is clear from the outset that there are class members who do not have a claim. And that's the winners and losers point. So I've taken, even though Mr. Ward doesn't pursue his per capita alternative, it's a useful way to illustrate the point that what we do know is that an alternative distribution system cannot replicate where the royalties truly lie. So it's always going to be steering some of those royalties to people whose works weren't performed. And whichever policy, distribution policy is adopted, there are going to be winners and losers within the songwriter class. And so you can easily illustrate that with the per capita alternative, that Mr. Sheeran we can say now, does not have a claim. Because if that were the counterfactual that were being pursued, it's obvious now that he's better off under the current system than he would be under that alternative system. And the same is true whatever alternative is selected. And that goes back to the point that songwriters are not a monolithic group. So they're affected differently by the current proposal and they would be affected differently by any other proposal. So having having given the court an overview, I hope, of our response, I want to order my submissions as follows. I want to take you to the Supreme Court's judgment in Evans and explain the relevance of that case for this appeal. And then I'm going to address ground 2, including some of the relevant case law, and then ground 1, including some of the relevant case law. So I'm going to do it in that order. So if we could start with Evans. So that's in the second authorities bundle, behind tab 17. And if we can take it from page 849. And one of the reasons that the Supreme Court's judgment is relevant, and of course the judgment was handed down after the tribunal judgment in this case, is that what you'll have seen from my learned friend's skeleton argument, though sensibly not really pressed on the court in this appeal, is much reference to acting in accordance with the objectives of the regime, which are stated in the PCR skeleton argument as being to facilitate collective proceedings. And what the Supreme Court does is explain that there are 2 different objectives of the regime, and you see that at paragraphs 26 to 27 of the judgment. So referring back to the Commission Green Paper, you see a reference there to a need for measures to facilitate the bringing of actions for damages, but at the same time, such changes should not lead to a situation in which undertakings engaging in lawful economic behaviour are placed at undue risk of having to pay unjustified claims or to change their behaviour in order to avoid costly litigation. And then you can see at 27, the tension between these objectives and the need to strike a balance between them underlies all the reform proposals and is at the heart of the issues arising on this appeal. So the Supreme Court very carefully explained that there are 2 objectives which go in different directions, and there's a need to balance them. And then if we can go forward, please, to page 862. And if we look at, I do want to point out, my learned friend didn't take you to it, but it's relevant to ground 1. If you look at letter C, you see there the sentence, that was despite the fact that the collective nature of the action itself reduces the burden on the claimant, since there's no need to prove that individual members of the class have suffered loss. And that's a reference to the aggregate of being able to claim damages on an aggregate basis. And I'll come back to that. And to foreshadow what I'm going to say, we say that it's common ground that where an aggregate award of damages is sought, the class representative will not have to prove the loss suffered by each individual. That's the point of having this innovation in the regime. But that does not permit a PCR to include in the class members who have not suffered a wrong and don't have a claim at all. And again, I'll come back to that under ground 1. But then if we go to the bottom of the page, you see there that what the Court of Appeal had said in this case was that the weakness of the claim was not a factor that was relevant to the question of whether opt-out proceedings should be permitted. And the Supreme Court disagreed with that. And you can see there that they say that there's no mystery about the significance of this factor. That's the strength of the claim, the merits. If a claim is weak, that militates against affording claimants the advantage of an opt-out process, with the concomitant disadvantage that a defendant may feel commercial pressure to settle such a claim, even though it would be likely to fail at trial. And they refer back to the legislative history. I took you to some of the paragraphs addressing that. And then you see at 89 the reference to Lord Sales and Lord Leggett explaining that the class action procedure is capable of of having an enormous leveraging effect in terms of pushing defendants to settle claims which are unmeritorious. You see that described at paragraph 90. Leveraging effect of opt-out collective proceedings, explaining the incentives which the opt-out procedure creates to settle even weak claims for more than merely nuisance value, and hence to bring weak claims as opt-out claims. And then at 91, if the merits of a claim are very weak, as the tribunal assesses them to be in this case, it's unlikely that the tribunal will be justified in conferring on the proposed class the significant leveraging advantage associated with opt-out proceedings. That's likely to be unfair as between claimants and defendants. And then 92, again, that would be to assist the claimants to extract value from an unmeritorious claim. And then you see that at 92 and 93, that this would be likely to fall to allot an appropriate share of the tribunal's resources to the claim, divert the tribunal's time and attention to managing other claims, and that it would be to allow collective proceedings to be pursued on an opt-out basis in such circumstances would also tend to be contrary to the tribunal's obligation to deal with a case at proportionate cost. And so at 94, to sum up, if the claim is very weak, it's likely to be more difficult to justify resort to the opt-out procedure as striking a fair procedural balance between the claimants and the defendants.
This was all being said in the context of a passage to do with opt-in or opt-out.
Yes, my lord, and that's a point that my learned friend makes in his skeleton argument. But what we say about that is two things. We say that that was the context in which it arose here, but the considerations, the principles which are being drawn by the Supreme Court about the nature of the regime and the nature of opt-out proceedings apply in any event. So in this case, it's true, there wasn't a debate as to whether the proceeding should be opt-out or opt-in, but all of the points about allowing opt-out proceedings to proceed in circumstances where the claim is weak because of the leveraging effect apply with equal force even where there isn't a debate between opt-out and opt-in. And of course, the second point we would make is that the tribunal in FX, in the Evans case, had accepted that if they chose opt-in, there would in fact be no proceedings. So everybody knew by the time it got to the Supreme Court that it was opt-out or nothing. And that, in a way, helps illustrate why the point made by my learned friend, which is all of this can be confined to a situation where the debate is between opt-out and opt-in, is incorrect. And then just...
Well, what's the position in the current case? It's sought to bring this on an opt-out basis.
Yes.
And there's not been a debate as to whether it should be opt-out or opt-in?
No, there hasn't been a debate. So...
it's still an open question if the matter goes forward at all? If you lose the appeal?
Well, the only basis on which it's been put forward is on an opt-out basis.
But the tribunal can say, can't it, we're not going to let it go forward on an opt-out basis, but if you want to bring it forward on an opt-in basis, we might.
It could say that, but there hasn't been a debate about that. And then if you could turn, please, just to page 862.
And again, on the point you made about it being common ground that in fact they wouldn't go forward in that case.
Yes.
I think the Supreme Court concluded that that was just because on the evidence there were large financial institutions which said, as a matter of fact, we're not going to pursue this claim. But it didn't mean that they were not otherwise suitable as opt-in proceedings. It wasn't, as it were, that it would be impossible or impracticable for it to go ahead on that basis. It was just that there was evidence that they wouldn't.
And so it was impracticable on that basis? So
Not really. It was. I think the court said that it was practicable, but as a matter of fact, the financial institutions had said that they weren't going to bring the claim. That's as I understand.
My Lord, yes. So I would, the way that I read
So it's
it,
up to them, in other words.
so the way that I read it all is that the tribunal had accepted that in principle opt-in might be appropriate.
Yeah.
That's correct. But then they found that as a matter of fact that wouldn't happen because the larger institutions that you would need in order to attract the funding and so on would not opt in.
So it just wouldn't be viable.
Wouldn't be viable.
But that was because of a decision that they had made, not those particular financial institutions had decided they didn't want to, or rather the large financial institutions that you would need had just decided they didn't want to do it. Is that?
And that made it impracticable because, of course, you could, in theory...
Made it unviable.
Unviable, exactly.
Yeah.
Exactly. Yes, and there's there's a long tail of very small potential class members, and it was found that they wouldn't make the effort to opt in, and their claims by themselves wouldn't make it financially viable. So that was really that was the reason there. Of course, in this case, it's difficult to see. There's a fundamental problem with both opt-out and opt-in, if I can put it that way, because nobody knows, no member knows whether or not they would benefit from the claim. So this is a fundamental problem. Because no alternative distribution system has been put forward, it's impossible for anybody to know whether they would benefit and want to take part in this claim. And that makes it doubly inappropriate for it to be an opt-out claim, because you've got Ed Sheeran, for example, thinking, well, I'm quite happy with the current distribution system. If it turns out to be a per capita one, that's going to be problematic for me. I won't have suffered a loss, and I don't want to be part of these proceedings, but it's impossible for him and others in his position to make that call at the outset, which is what they need to be able to make. Equally, opt in. How can anyone possibly opt in when they don't know what the alternative is that's being posited? So it's a problem on both counts. And so...
Is it worth just mentioning for the record that none of us know what Mr. Sheeran thinks?
None of us know what Mr. Sheeran thinks. That's correct.
I understand that to be, as it were, a hypothetical.
It's a hypothetical. But my Lord has the point that depending on the position, it's easily illustrated with the per capita idea that was floated in my learned friend Skeleton. But whichever alternative system you take, there are going to be winners compared to the status quo and losers. And the critical point is, you should be able to know if you're a member which you are. Now, there's one more part of this judgment that I just want to show you. So if we go to page, 866, so by letter B to C, there can equally be cases of which the present is one, where even if the claim surmounts the summary judgment strikeout threshold, the tribunal is able to form the view that the claim is so weak that this points against allowing collective proceedings to be brought on an opt-out basis. And you have my point that all of the reasons for that, the leveraging effect and the waste of money that is incurred, stand, even though there wasn't a debate as between opt-out and opt-in. And then if you go, please, to page 869, paragraph 115, if you look at the middle of the paragraph, what the Supreme Court is underlining here is that the regime seeks to provide, this is halfway through the paragraph, is a reasonable opportunity not available previously for a group of claimants to club together, or in the case of opt-out proceedings, to be grouped together, to vindicate their rights in a way which would not be practical or cost-effective if they had to proceed individually. But the regime is not intended to immunise them completely from the usual background commercial considerations which have a role in determining when proceedings are thought to be sufficiently viable to be worthwhile. And we say, thinking about the Supreme Court's reasoning here, it reinforces the tribunal's conclusion, because we do respectfully submit that this is a weak, poorly thought out claim, which is flawed on its face, and the tribunal found it should not be permitted to proceed. The tribunal was right to take that decision. Had it not struck out the claims, it would have been allowing a weak, flawed claim to proceed with all the leveraging effects that this would have had against PRS.
But I thought that the strikeout was on the basis there was no arguable claim. And
Yes.
That's the test you need to meet. It's not, well, we can see there's a claim, but it's a weak one, and therefore we can strike it out. And I'm not sure the tribunal can do that, can it? It can't just say, although it survives a strikeout on the no arguable case test, we still think it's weak, so we're going to strike it out. What they can say is, well, we won't certify it on an opt-out basis.
My Lord, yes.
But that's not what they've done in this case. They've struck it out. And ground 2 is about whether they were right to strike it out.
Well, that's in a sense the function of our respondent's notice point. So we say that even if we say, my primary submission, let me make clear, is that the tribunal was right to strike this out, and that's what I'm going to focus my attention on. And we say that there are 2 points, really, we seek to derive from Evans. The first is that you see, and my learned friend submitted, that, oh, well, you should let this go forward to trial because there might be evidence that comes up to help us. And that really does, the Supreme Court's reasoning does militate against taking that sort of course because of the leveraging effects of these proceedings, opt-out proceedings against defendants. And then our respondent's notice point is that the tribunal would, had it had this judgment, it would have been entitled not to certify the opt-out proceedings, even if it hadn't been satisfied that it was so bad as to be liable to be struck out.
Yes, thank you.
Yes, exactly. So the tribunal, in finding that the strikeout, that the summary judgment test had been failed, did so on the basis that this was a very weak claim. So it was looking at the weakness of the claim. It wasn't a sort of a legal, a straightforward, it wasn't simply a legal point. So I wanted to turn, but I'm looking at the time, so it may be that it's convenient to turn to ground 2.
Yes, let's come back
at 2 o'clock.
Yes. How are you doing? You're on track to...
I'm certainly on track.
When are you expecting to finish?
I am. I mean, I will finish by 3:15.
Thank you very much. So 2 o'clock.